She is supported by university to obtain a PhD through the extended capacitation program at Bern University. Parallel to academic work, Professor Palmer was a trade negotiator and chief assistant for the Ministry of Trade of Costa Rica. A very impressive bio, and I'm sure that we'll benefit from her experience in that respect. So Professor Palmer will provide an overview of the key findings of the appellate body in this dispute, and will provide preliminary comments. Professor Malgesha Fitzmaurice holds a chair of public international law at the Department of Law, Queen Mary University of London. She specializes in international environmental law, treaties, indigenous peoples, and Arctic law, and has published widely on these subjects. Again, her bio is in the pack in front of you. She will comment and will focus primarily on the legal implications of the report from the perspective of public international law. Mr. Anthony Abad prefers to be called Tony. Is CEO of Trade Advisors, a firm specializing in international trade law and providing technical advice and assistance to various stakeholders. He presently serves as an independent policy advisor to the Secretary of Agriculture and to the Philippine Senate. Again, the full bio, or at least abridged bios, are in the packs in front of you. Mr. Abad will discuss the implications of the report and FTA negotiation practices. Mr. Adrian Hewitt is a senior research associate of ODI. He was deputy director of ODI for 11 years and the Institute's acting director in 1998. He was the head of the ODI fellowship scheme until 2013, increasing the numbers of economists in the post to 100 and extending the scheme's research to governments of 25 countries. His bio, you can find it in the pack in front of you. Mr. Hewitt will comment on the economic implications of the dispute in the context of implementation. May I now invite Carolina to make her comments on the case, and Carolina, you have some good 15 minutes to do this good job. You have the floor.
Okay, to do this hard job of explaining 100 pages in 15 minutes. Good morning. Well, I appreciate the invitation to talk about this dispute. I am very interested in dispute, as you will see, not only because it's my region, Latin America, and in this case, Guatemala, Peru, but also because I think this case is going to change some of the disputes that we have seen. I think there's going to be a before the WTO and after the WTO after the appellate body's findings in this case. I'm going to explain them, and then I'm looking forward to the discussion on this. So first of all, let's take a look at the measures at issue in this case. The measure at issue is additional duties imposed by Peru on imports on a number of agri-products, certain types of milk, maize, rice, and sugar, determined using the PRS, Price Range System. In Spanish, it's Sistema de Franja de Precios. The PRS consists of a floor price. This is very briefly explained. It's a little bit more detailed in the case, but briefly, it has a floor price and a ceiling price, reflecting the average of international prices over a recent past period of 60 months. Then there's a cost, insurance, and freight reference price. It reflects the average international price over a recent past period of 2 weeks. And then the PRS results as an additional duty that it is applied when the reference price is lower than the floor price. If the reference price is above the floor price but below the ceiling price, then no additional duty is applied. If the reference price exceeds the ceiling price, the applicable tariff is reduced. So this is the measure at issue in brief, very briefly explained. Then we have the claims by Peru that are presented in the case. And we have the first claim is that Peru contends that the panel erred in finding that the additional duties are not ordinary custom duties. The second claim is that the panel acted inconsistently with Article 11 of the DSU. And then the third is that Peru requested that Guatemala did not initiate in good faith, contrary to Articles 3.7 and 3.10 of the DSU, since it had accepted the maintenance of the PRS in the FTA that they signed. This was on December 6th, 2011. Some of the arguments, according to Peru, well, the first one, again, they should be ordinary customs duties, according to Article 11.1b of GATT. Then the second one is that this measure or this price range system is outside the scope of Article 4.2, Agreement on Agriculture, and second sentence of Article 2.1b of the GATT 1994. And then the third argument is that if there is an inconsistency between WTO law and the FTA, the terms of the FTA should prevail in any case. In the report of the panel, not the appellate body, but the panel found that, and here there's a lot of findings, but I made a summary of them. You can see them in the slide. So the first one is that there is no evidence that Guatemala acted contrary to good faith. This is on the panel report. The second one, the duties resulting from the PRS constitute variable import levies, or at least similar to it within the meaning of footnote 1, Article 4.2 of the Agreement on Agriculture. The third one is that the duties resulting from the PRS do not constitute minimum import prices, neither are they similar to minimum import prices within the meaning of Article 4.2 of AOA. The third one is that the fourth one is that by maintaining such measures, Peru acted inconsistently with its obligations of Article 4.2 of Agreement on Agriculture. Then we have the additional duties resulting from the PRS constitute other duties or charges within the meaning of the second sentence of Article 2.1b of the GATT 1994, not in their schedule of concessions, which means that they are acting contrary to Article 2.1b of the GATT. And then the last of the findings of the report, inasmuch as the FTA Guatemala-Peru had not entered into force, it was not necessary to rule on whether the parties could modify their rights and obligations under the WTO covered agreements. Again, this is a very brief summary of the panel's finding. And the issues raised, well, I mentioned some of them before the appellate body. We have Articles 3.7, 3.10 of the DSU. They claimed that these are new claims, and they claimed the good faith in that issue raised. Then second, footnote 1 of Article 4.2 of AOA, whether the panel erred in the assessment of the variability and ordinary customs duties in assessing these measures as variable or being customary custom duties. Third, with respect to the additional duties resulting from the PRS, that the measure is an other duty or charge inconsistent with the second sentence of Article 2.1b of the GATT, whether the panel erred in finding that the additional duties are not ordinary custom duties, and whether it failed to make an objective assessment contrary to Article 11 of the DSU by failing to examine evidence. Then we have also an argument according to the interpretation of Article 4.2 of AOA, Article 2.1b of the GATT, in accordance with Article 31 of the Vienna Convention, whether the panel should have taken into account the FTA and ILC Articles 20 and 41 under Article 31.3 of the Vienna Convention, whether it failed to take it as a subsequent agreement according to Article 31.3 under Vienna Convention and as relevant rules of law applicable between the parties, whether the panel erred by not taking into account the FTA because it was not into force, and with respect to additional duties, this was another claim raised by Guatemala resulting from the PRS, whether they constitute a minimum import price or a similar border measure. It was raised by Guatemala that the panel had erred on this. Now, regarding the analysis of the appellate body, first we have the good faith claim. Regarding good faith, Articles 3.7, 3.10 of the DSU, basically, the AB concluded that the argument by Peru is not a new claim, and there's enough jurisprudence to support this. For example, Canada Aircraft. Peru's arguments relate to issues of law that were already covered in the panel report, and the arguments do not require consideration of the new facts, and therefore Guatemala is not, or the panel was not in breach of Guatemala's due process rights when taking a look at the issue. So basically, it upholds the panel finding in paragraph 8.1 of the panel report that there is no evidence that Guatemala brought these proceedings in a manner contrary to good faith. Oh, this is regarding the good faith claim. So the first one is regarding the admissibility, which was admissible, and the second one is regarding the claim itself of good faith. When the appellate body said that, well, it was seen in cases before that before bringing a case, a member shall exercise its judgment as to whether to bring a case and are thus expected to be largely self-regulating, meaning that in this case, if Guatemala thinks this is the effective procedure to the functioning of the WTO, then it is accepted to take the claim. Then we have Peru's claim under Article 4.2 of the Agreement on Agriculture and Article 2.1b of the GATT. Regarding this, basically, well, we have Article 4.2, members shall not maintain, resort to, or revert to any measures of the kind which have been required to be converted into ordinary customs duties. On the first center of Article 2.1b of the GATT, certain products shall be exempt from ordinary customs duties in excess of those set forth and provided in the relevant schedule of concession. So in the case Chile price band system, already the appellate body stated that the structure and logic of footnote 1 made clear that variable import levies and minimum import prices cannot be ordinary custom duties. Also, the AB has stated that the term ordinary custom duties can be interpreted the same way in both of the provisions. So it's the same term in both provisions. Since the panel found that those additional duties constitute variable import levies or border measures similar to a variable import levy within the meaning of footnote 1, therefore it concluded that the additional duties cannot constitute an ordinary custom duty. Then we have Peru's claim. Okay, we already seen this one. Cannot be ordinary customs duties. The panel found that the additional duties constitute variable import levies, and therefore the AB upholds the panel's findings. Regarding the relationship between WTO and FTA provisions, and this is where it also gets very interesting, there's some arguments that are raised. Peru contended that the panel should have interpreted the term shall not maintain in Article 4.2 in the light of the provisions of the FTA between Peru and Guatemala as allowing Peru to maintain the PRS. Peru argues that paragraph 9, Annex 2.3 of the FTA is relevant to the interpretation of Article 4.2 of the Agreement on Agriculture and Article 2.1b of the GATT. in accordance to Article 31A and C of the Vienna Convention. And Peru also contends that according to ILC Article 20, Guatemala's approval and ratification of the FTA amounts to a waiver in the sense of Article 45A of ILC articles. What Peru is meaning by this is that the panel should have interpreted the term shall maintain as it may maintain. So the AB understood that Peru suggests that by relying in paragraph 9 of the FTA, Articles 20 and 45, the panel should have interpreted those provisions as allowing Peru to maintain the PRS. However, this is when the appellate body rules. It says, while the context is a necessary element of an interpretive analysis under Article 31, its role and importance in an interpretive analysis depends on the clarity of the plain textual meaning of treaty terms. If the meaning is difficult to discern, determining it under Article 31 may require more reliance on the context and the object and the purpose of the treaty, and possibly other elements required together with the context and the tools mentioned in Article 32. The appellate body does not see how the textual term shall not maintain in Article 4.2 of the AOA should be read as meaning may maintain based on a provision found in an FTA. This is, I'm literally reading what the appellate body said. The appellate body does not see that Article 31 can be used to develop interpretations that appear to subvert the common intention of the treaty parties as reflected in Article 4.2 AOA and Article 2.1b of the GATT. This is here, of the GATT 1994. The AB understands that with multilateral treaties, such as the WTO covered agreements, the general rule of interpretation in Article 31 of the Vienna Convention is aimed at establishing the ordinary meaning of treaty terms, reflecting the intention of the parties to the treaty, and not just the intention of some parties. Therefore, the AB finds that Peru's arguments are beyond the scope of an interpretive analysis exercise, as envisaged in Article 31 of the Vienna Convention and 3.2 of the DSU. The other argument by Peru is that it should be a subsequent agreement, that the FTA is a subsequent agreement according to the ILC. In this case, or in this part of the arguments, we have the findings of the appellate body, which are, well, number one, in order to be relevant for purposes of interpretation, rules of law, in this case Article 31, must concern the same subject matter as the treaty interpreted. This was already said in EC large civil aircraft case. However, the issue at stake was regarding the variable import levies, minimum import prices, similar border measures, etc. So in this case, the appellate body did not see how the FTA and the ILC Articles 20 and 45 can be considered as rules concerning the same subject matter as Article 4.2 AOA and Article 2.1b of the GATT. Without reaching the question of whether FTA Article 20 and 45 are applicable to the parties, they disagree that they constitute relevant rules of international law in the meaning of Article 31, and therefore the FTA is not a subsequent agreement. The AB concluded that the FTA and ILC articles are not relevant to the interpretation of Articles 4.2, Agreement on Agriculture, and the Article 2.1b of the GATT, and the FTA does not qualify as a subsequent agreement. Therefore, there's no need to address the question of applicability. Moreover, Peru, as you've seen, has not ratified the FTA. The AB also notes that by allowing Peru to maintain its PRS, such an approach would suggest that WTO provisions can be interpreted differently, depending on the members to which they apply and on the rights and obligations under an FTA, which shouldn't be the case. Furthermore, the parties disagree on whether the provisions of the FTA indeed permitted Peru to maintain a WTO inconsistent PRS. This was also one of the arguments by Guatemala, because they state that it was not a statement WTO inconsistent PRS. The statement or the provision within the FTA said that they allowed to maintain the PRS, but not a WTO inconsistent PRS. Also, paragraph 1 of Article 1.3 of the FTA states that the party confirmed their rights and obligations under the WTO. Therefore, it gives more room for the appellate body to rule on this. And the appellate body noted that the WTO agreements contain specific provisions. However, Article 24, which could have been analyzed in this case, was not even invoked by Peru in its claims. So it's not relevant to the analysis. Okay, and then coming to some of the conclusions that we have. Just a second. Yes. Coming to some of the conclusions on this part, we have that the appellate body upholds the panel's findings in paragraph 8.1b of the panel report, that the additional duties resulting from the PRS constitute variable import levies within the meaning of footnote 1 of Article 4.2 of the AOA, and in paragraph 8.1d of the panel report, that by maintaining a measure that constitutes a variable import levy, Peru is acting inconsistently with its obligation under Article 4.2 of the AOA. The second one is that the appellate body upholds the panel's findings in paragraphs 8.1e of the panel report, that the additional duties resulting from the PRS constitute other duties or charges imposed or in connection with the importation within the meaning of the second sentence of Article 2.21b of the GATT. And by applying such measure without having recorded it in its schedule of concession, Peru acts inconsistently with its obligations under WTO law. Then just very quickly, if I have time still, I'd like to give you a reference on the minimum import prices argument that was raised by Guatemala. So this argument basically concerns the argument by Guatemala that the measure also can be considered a minimum import price. So what the appellate body said regarding this subject is that minimum import prices are schemes that generally or normally operate in relation to the actual transaction value of imports, so that if the transaction price of an import is below a specified minimum import price, an additional charge is imposed corresponding to the difference. It is a similar import price when it shares a sufficient number of characteristics with and has a design, structure, and effects similar to a minimum import price. In the appellate body's view, the examination of whether a measure is a minimum import price within the meaning of footnote 1 should be based on evidence concerning the operation, impact, analysis, design of the structure of the measure. But the panel in this case did not sufficiently engage with the relevant elements of the design, structure, and operation of the measure, and therefore reversed the panel's findings, resulting that the PRS do not constitute a minimum import price. On that basis, the appellate body said that since this examination should have been based on evidence concerning this operation, impact, analysis of the design and structure of the measure, and it is not provided, then it reverses what the panel stated, that they are not the minimum import prices, but at the same time, they considered that they don't have the sufficient information in order to rule on this matter and to be able to complete the legal analysis, which was requested by Guatemala. And therefore, they cannot reach a conclusion on this minimum import prices matter. Okay, in summary, the appellate body found that Peru's arguments regarding the interpretation of Article 4.2 AOA, Article 2.1b of the GATT, in accordance with Article 31.3a and c of the Vienna Convention, are within the scope of the appeal, and therefore they admitted to rule on these matters. Then the appellate body found that Peru's argument that the panel erred in its interpretation of Article 4.2 of the AOA, Article 2.1b of the GATT, because it failed to take into account under Article 31.3 of the Vienna Convention, Articles 20 and 45 ILC go beyond the interpretation of Article 4.2 and Article 2.1b in accordance with Article 3.2 of the DSU and Article 31 of the Vienna Convention, and amount to arguing that by means of the FTA, Peru and Guatemala actually modified these WTO provisions between themselves. So in this case, this couldn't be the argument. The appellate body found that the FTA between Peru and Guatemala and ILC Articles 20 and 45 are not relevant to the interpretation of Article 4.2 of the AOA, Article 2.1b of the GATT, within the meaning of Article 31, 3, and c of the Vienna Convention, and that the FTA is therefore not a subsequent agreement regarding the interpretation of these both WTO provisions. Then it found that the panel did not commit an error by not interpreting the 4.2 AOA and Article 2.1b of the GATT, taking into account the provisions of the FTA and ILC Articles 20 and 45 under Article 31.3 of the Vienna Convention. And therefore, it found that the panel did not err in declining to make findings as to whether the FTA modified the WTO rights and obligations between Peru and Guatemala. So it upholded, but with a different argumentation. The appellate body upholds the additional duties resulting from the PRS constitute variable import levies within the meaning of footnote 1. This we already saw at the very beginning. I explained why, the reasoning, and that by maintaining a measure that constitutes a variable import levy, Peru is acting inconsistently with its obligations under Article 4.2 of the Agreement on Agriculture. Then it upholds, the appellate body upholds, that the additional duties resulting from the PRS constitute other duties or charges imposed or in connection with the importation within the meaning of the second sentence of Article 1, Article 2.1 of the GATT, and that by applying such measure without having it recording in the schedule of concessions is acting inconsistently. And then finally, the appellate body reverses the panel's finding regarding minimum import prices for the reasons we saw before, but it is unable to complete the legal analysis. So basically, the result of all of this is that the appellate body recommends that the DSB requests Peru to bring its measure to be consistent with the Agreement on Agriculture and the GATT 1994 to be put into conformity with those agreements. And I think that should be it.
Thank you, Carolina, for bringing to the fore the context of this event. I now invite Malgosia to make her comments, to focus basically on the legal implications of the report from the perspective of public international law. Malgosia, you have the floor. You have 10 minutes.
Yes, thank you very much. I am going to talk really only from the point of view of the public international lawyer. And I am not a WTO lawyer. Actually, when I read WTO cases, maybe I made a good choice, I always think. Well, anyway, I will, Carolina already raised some issues on treaty interpretation, so I will try to build on what she already said, but also raised the other issues which she mentioned, like the problem of good faith and Article 18 of the VCLT, which is very interesting issue. So in this case, under discussion, from the point of view of general international lawyer or law of treaties lawyer, I found the most important two blocks of discussion, good faith discussion, including Article 18, and of course issues of treaty interpretation. Good faith is, Carolina explained, Peru appealed the panel's conclusion that there is no evidence that Guatemala brought these proceedings in a manner contrary to good faith. And then Peru contended that Guatemala waived in the FTA its right to challenge PRS through the WTO dispute settlement mechanism, and that thus so as we can see, this case actually includes quite a extensive discussion on the issue of good faith. I am possibly, because I only have 10 minutes, to not to dwell too much on what the appellate body said about good faith, which you have on my handout, but basically say something about definitely about good faith in general international law. I would also like to mention that this case was very interesting because Article 18 was invoked, and Article 18 is based on good faith in general international law, and generally it's based on a premise that the parties, the states which signed the treaty, have obligation not to defeat the object and purpose of a treaty prior to its entry into force. So the question arises, what is the legal content, the normative content on this Article 18 of the VCLT? I would say straight from the outset that this is one of the most oblique provisions of the Vienna Convention, 1969 Vienna Convention. The general view in theory and practice of the law of treaties is that this is more like an wishful thinking obligation without a really strong legal content. So this article was very rarely invoked in the practice of international law. So the question is, does it invoke the responsibility of states when they act against the purpose and object of a treaty? Well, in my view, and also view of other of my colleagues in the law of treaties, it really it's not so strongly formulated. It doesn't really have such normative content as to invoke state responsibility if a state acts contrary in a manner inconsistent with a treaty it signed. However, there are two exceptions, two examples in the general practice of general international law when the US administration signed two treaties, and then just to be sure that that US doesn't incur state responsibility, clearly stated that signing of a treaty, and this is one Rome Treaty of the International Criminal Court, and the other the Kyoto Protocol, that they don't incur any international responsibility for signing. And I can say in bad English that they de-signed the treaty. So it is a very interesting article very rarely invoked. However, it was invoked in some before domestic courts. I don't have time to talk about it, but if anybody is interested, it was before the Supreme Court of Benin. It was a case based on Article 18, and in fact, it is quite curious that in international forum, Article 18, i.e. good faith, related to it, it's not really invoked, but it plays a more substantial role in domestic law. So now, perhaps I will say also the general issue of good faith in international law. And the main issue, in my view, of the status of good faith in international law is whether it should be a self-standing principle or norm of international law to institute proceedings before international court and tribunals. I think that it is also considered to be a very weak ground, and in Nicaragua, Honduras case from 1988 before the International Court of Justice, the court said that it cannot be an independent ground of litigation if none exist therein. Another example is the nuclear case, test case, when France made unilateral declarations, erga omnes, to the whole world that it will stop nuclear testing. And on this basis, the court passed a judgment very much criticized. Why? Also, one of the reasons was that Australia and New Zealand thought that basing the judgment of a good faith of France making these unilateral declarations was a very weak ground to pass the judgment. So as we can see, Article 18 and related to it the issue of good faith are very weak and not quite well understood issues in general international law. So I think that in that the appellate body was right not to attach too much importance to Article 8 and related issue of good faith, because there is really not settled theory or international law practice to back up arguments based on good faith and Article 18. Yeah. So yeah. So this is all about good faith. So I have to move on. Now the general issues of treaty interpretation. We always read, general international lawyers or attempt to read carefully the decisions of the appellate body and panels of the WTO, because it always brings something new and exciting into the interpretation of treaties and into understanding of Article 31 of the VCLT, which is very often invoked by appellate body. So I would like to specifically make some comment on the statement of appellate body, which Carolina mentioned, that the appellate body stated that while context is a necessary element as an interpretive analysis under Article 31, its role and importance is an interpretative exercise, depends on the clarity of the plain textual meaning of the treaty terms, and then it continued that if the meaning of treaty terms is difficult to discern, determining the ordinary meaning under Article 31 may require more reliance on the context and the object and purpose of the treaty, and possibly other elements considered together within the context and the tools mentioned in Article 32. Well, this is a very, for me, rather puzzling passage in the reasoning of the appellate body, because Article 31 is called General Rule of Interpretation. So it has a unitary meaning, rule, not general rules of interpretation. And this has a meaning to it, i.e., object and purpose of the treaty, together with its context, have to be taken together while interpreting the treaty. So it is quite interesting to see that appellate body relies on object and purpose, then context, and then maybe Article 32. But all this, except for Article 2, it's one rule of interpretation. So it has to be taken together, in my view, object and purpose and the context of the treaty. This is actually, I would say, a basic rule, interpretative rule, and already before the Vienna Convention was drafted and came into force, Gerald Fitzmaurice wrote very important article in '59 in British Yearbook on rule of interpretation based on the practice of the PCIJ and ICJ. So he gave these principles of interpretation, and these principles of interpretation were actuality or textuality, natural and ordinary meaning. So one of the principles, not like isolated principle that we have to look at the ordinary meaning, and if it doesn't render the required result, then we go further. And the principle of integration. So we have to look at the whole treaty as a whole. And the Vienna Convention, Article 31, actually incorporates his finding in Article 31 on treaty interpretation. I am almost running out of the time. Yeah, I can see the chair. So I will now move now to maybe the questions of Article 31(3) A and C, which is also extremely important in treaty interpretation. So what constitutes an agreement within the context of treaty interpretation? It's one of the issues which are still very debated between international lawyers, i.e., whether the practice of all the agreement between all the practice is necessary of the parties to the treaty, or maybe not. I think that the majority of theorists are of the view that it actually should be the agreement between all the parties to the treaty. When I look at the WTO practice, it strives for consistency. So it's only Article 24 which allows for certain departures. So possibly the findings of the appellate body were in line with the general approach of appellate body towards consistency of WTO agreements. Now, quickly on the C, Article 31C, which is so-called in general international law the principle of systemic integration. I would like to say that it's also one of these points of the law of treaties which is quite debated. There is no really agreement, and this principle of integration has been dormant in the law of treaties for many years until it came to prominence in the oil platforms case. Otherwise, it completely was unused. Now, it is a fashion to always invoke this provision with no particular success. This provision also is very often invoked before the International Court of Justice, and after initial success in all platforms case, it has actually lost its prominence. The last time it was relied on in a very extensive way was the whaling in Antarctic case before the ICJ, in which case Australia and New Zealand relied on the environmental agreements other than whaling convention to prove development of international law. However, in international law, pure international law, it's really not clear whether it possibly also includes the time element, which was excluded from interpretation of rule of interpretation in Article 31, or as it is more used at present, putting a treaty in question into context of other international agreements. Thank you very much.
Thank you very much, Magosha. I now invite Tony to give us his comments from the FTA negotiation perspective. Tony?
Thank you. Mr. Chair, I won't dwell too much on details and hopefully won't take all of the time required. I'll just zero in on some thoughts that I've gotten or that have come to me, having read the cases and reflected on them, and then now I put on two hats. In a past life, I was part of the negotiating team for the Philippine government as a tariff commissioner. The other hat is more recent. I actually am a regular panelist. I've gone through 3 disputes already in the Rules Division. So it's given me 2 perspectives, basically. One that maybe started out very differently. My view on treaties and the negotiation process that leads to the treaty and the interests that go into it. You know, what you're fighting for, what you're trying to establish by engaging in the negotiation process. Then I find myself sitting in a panel, now going through a case details and looking at legal provisions of national laws and treaties and even the WTO agreements, and actually end up wondering together with my fellow panelists, why was it written this way? You know, in other words, if it were written with an eye to avoiding the dispute or making sure that, really making sure that the dispute doesn't happen, then the whole process of how you come up with a treaty, how you come up with legal provisions will be quite different. And that's where I'll sort of zero in at the end. Now, the case is a very interesting, it's a very enlightening case. It's interesting that it's between these 2 developing countries, Peru and Guatemala, and that they actually were in the midst of a negotiation for a bilateral treaty. So important questions come up, although clarified by the panel and the appellate body regarding good faith as that obligation arises in the process of negotiation, and the question of jurisdiction and forum selection. You know, what is the proper forum in a dispute wherein an FTA has been coupled together, sort of overlaps with a discussion on WTO agreements. And then the applicability of treaty provisions vis-a-vis WTO provisions. In other words, the statutory construction of international law provisions, and then the whole possibility that you could say that you waive the right to your WTO obligations and rights by writing it into a treaty. Now, in the end, it was found that there was a lack of clarity in the treaty in question. But still, it leaves us wondering, why would it get to that point? And what is the implication later on when you have disputes and allegations or arguments saying that, well, we basically waived our right to be under the WTO agreements, and in effect, you're carving out a new set of provisions beyond the multilateral system. So let me go back to my own negotiating experience, what happens, and I'm sure most of you in this room probably are familiar. We do have guidelines back home, especially now that we are part of the ASEAN Free Trade Area, the AFTA, and now the ASEAN Economic Community, which is coming up very soon, together with APEC, have provided a number of or a set of guidelines on how to negotiate a treaty. And the process basically goes, you set negotiating objectives. You see the common interest that you have with a negotiating partner country or a group of negotiating partner countries. You go for a wide stakeholder consultation process, which now is common. You find this common. Questions might arise about who represents the national interest when it comes to these consultations, but in the end, well, the government will be able to will say that that is the national interest. They form a negotiating team, and they are given a mandate. They hold their meetings, set timetables. The concept of early harvest sometimes comes up, wherein there are early commitments that are set, and finally you finalize annexes, schedules, and side letters, and then you finally complete the agreement. And most importantly, I think at the end, is that there's a ratification process to legitimize the FTA or the RTA in question, and it becomes in force. So it's also important to take note that, well, you should have a ratification process, and before that, it's very difficult to actually invoke an FTA or RTA. Now, there is the need to maintain some WTO consistency, and we have, this is embodied in the exceptions provided by for example, Article 24 of the GATT and Article 5 of the GATTs. And recently, WTO has instituted a transparency mechanism wherein there's an early warning system for negotiations. You have to actually notify beforehand or at the onset of a negotiation process the draft RTA, and that notification process should have actually provided the opportunity to analyze, to vet, and to really dissect draft RTAs. But then, well, in reality, there's a question about the transparency, whether there really is transparency in the negotiation process. And I understand there's a large Trans-Pacific agreement that seems to lack the transparency that would allow us to actually understand and criticize and decide whether there is indeed WTO consistency between that proposed agreement and well, WTO provisions. All, or not most, of the negotiations I've encountered, especially of late, will declare already a WTO plus objective. In other words, that they are actually entering into the intention is to enter into the treaty to be able to establish their common interests, but at the same time to also promote WTO provisions and WTO agreements. And, well, the reality is negotiations are really a political exercise, and there is a negotiator's discipline as opposed to, I guess, the dispute settlement discipline. And those two are worlds apart. So I look back on this hat of being a negotiator and the kind of dealings, the kind of concessions you come up with. And the concessions come at the 11th hour. They usually come almost towards the end of the process. That's my own experience. And what happens is provisions are actually inserted or revised, and then there's this mad rush to finish and conclude the negotiation process and to have it ratified in time for a certain deadline. And that's oftentimes how these provisions get in to the treaties and gives rise to this problem. There may be, well, there may be an intention to actually go against or to carve out from the WTO disciplines, in which case you're actually coming up with a WTO minus situation. And then the issue will arise about what provision will be applicable in this case, just like in this case. But with clarity, it's possible that the possibility that you could actually carve it out is there. But in the end, I think the biggest problem is really the lack of clarity. And also the lack of clarity, okay, which is highlighted by the appellate body, the lack of clarity may actually be intentional, you know. The process of trying to come up with an understanding between two or more countries is oftentimes mixed with other interests aside from the economic and the business interests, and we also know that. And the relationship between political interests and security interests may legally not be visible, but certainly are there, and might explain why there may be a lack of logic in how economic provisions in economic treaties are drafted. So in the end, it's about really trying to bring together the dispute settlement discipline that we see. You know, for those who appreciate and have experienced actually the dispute settlement process here in the WTO, as it's gained traction over 20 years, and it's actually come to a level of institutionalization that actually strengthens, to a certain extent, the WTO. It's important to bring that discipline into the negotiation process. And I know it's easier said than done, because another observation I have is that the people who are involved in the negotiation actually have no inkling, and oftentimes are completely disconnected from the WTO, and knowledge of the WTO and understanding of the WTO. These are bureaucrats, diplomats who come from their respective ministries representing certain interests. Now, politically, they are there to help preserve the national interest, but at the same time, when we say that we want to be WTO consistent, then states engaged in negotiations should sincerely and in good faith now really involve the WTO, not just I guess not just by the notification process, but by really analyzing and vetting every provision of the treaty beforehand, with the help of those who are aware of the agreements, who understand the agreements, and who can foresee what might be another interesting dispute like the one we had today. Thank you.
Thank you, Tony. I now invite Adrian to give his comments on the economic implications of the dispute in the context of implementation. Adrian, you have the floor. 10 minutes.
Thank you very much, Chairman. And I'd like to thank the presenters who've preceded me for some very interesting insights, and also ICTSD for the invitation, and indeed the government and Ambassador of Finland for making this all possible. As Darlington said, I've been asked to discuss the economic aspects of a number of things, including the Peru special agricultural duties, its price range system, but also the very interesting ruling in favor of Guatemala, the outcome of the dispute settlements arrangement, and so the potential implications for developing countries as a whole, other developing countries, even outside, especially outside Latin America. I'm going to try and do this by looking at possible micro or macroeconomic policy tools, both at the domestic and the international level. At least that's what I've been asked to do, although I come to this with a little bit of skepticism and not complete expertise, but a little bit of expertise too. And I'll look carefully at this price ban system that was declared invalid. But I think the idea, the reason why I'm here is that there's a hope, there's an idea that this could be used for some form of commodity price stabilization or achieving commodity price stability, and ultimately the philosopher's stone to increase production, raise farmers' incomes, and so on. But that's going a long way. And as soon as you start talking about agricultural protection mechanisms, I think we also need to think about biblical moats and beams. So it's, from people in Europe, it's a bit awkward to talk about agricultural protection when we've got the CAP, the Common Agricultural Policy, which at one stage used to absorb 3/4 of the whole budget of the EU. It's less now, but it's still there. Anyway, the first thing to note that as an economist, I'm in a minority here, and I had much to learn, and I have learned a lot already from the musings. I'm sure that's not the right legal term, but anyway, the musings of trade lawyers and legal analysts are on the platform today, including about an FTA that was signed but not ratified by both parties, about FTAs or RTAs in Tony's case that possibly might trump multilaterally negotiated global trade deals going right back to the GATT. I've learnt more about the Vienna Convention than I thought I knew originally already, and I've got some glimpses of possible futures for the WTO itself. But I was helped by that, by the interview this morning by the FT by Roberto Azevedo, the Director General, where he is admitting that Doha is stuck, but that the WTO is no longer paralyzed. This is an optimistic view from the Director General. In other words, the WTO is no longer in existential angst. The therapy is coming to an end, and the 14-year-old Doha round might even seem to be promising now. And I say that with no irony, because things can be rescued, and he's probably the best person to rescue it. But do economists have a lot to add? The lawyers have been pretty rigorous, and of course they need to be. As I recall, the WTO itself used to be dominated by economists, by trade economists. I don't think it's the case now. I think the lawyers have taken over, and it's probably better that they have. But at least in the past, the rounds took a little less time to complete. But we always used to say, even amongst economists, that one or two of the jewels in the crown of the GATT and the WTO were the trade disputes procedures, as well as the trade policy review mechanism and so on. So here we have the trade dispute mechanism with a vengeance, in a very interesting case between two Latin American countries where it's very important to look at the fine print. Now, economists may have something to add on the microeconomic aspects of this. After all, that's how prices are formulated, and the PRS, aberrant though it was declared to be, is at least about prices. Or at least it's an attempt to influence prices, domestic prices, as well as constitute some form of protectionism. Right, I'm not going to do a riff about what happened in Europe and the CAP as well, but you have to be careful about going too far into this. The world is full of distortions, and that's why there's a need for the WTO to regulate and regularize them. On the other hand, economists advising on macroeconomics, there we get into difficulty because as Queen Elizabeth II herself said when she visited the London School of Economics, she addressed the economics professors and said, why didn't any of you tell us that this global financial crisis was about to happen? And they all looked a bit shamefaced, and subsequently the director of the school resigned, although that was more about Saif Gaddafi than Queen Elizabeth II. But anyway, there were some good economists who saw this coming, Nouriel Roubini, Vince Cable in her own country, and so on. But macroeconomics is still in a bit of a mess at the moment. It's still riven between Keynesians and Austrians, or even Thatcherites, who become budget balancers, and you see that problem arising in Europe because of Germany now. So I think we've got nothing to teach Peru and Guatemala more than the trade lawyers had. Macroeconomics currently is almost can almost be described as Wikipedia with regressions, not more substantial than that. Okay, but I was asked to comment, I think, because of my other exposure to this subject in work I've done over the years, including right back many years ago on UNCTAD for compensatory finance, commodity policy analysis, and so on. And this goes back to schemes like Staybeck, SISMIN, continues in the form of Flex that the EU still performs, and the now defunct schemes from the IMF like the CFF, the Compensatory Financing facility. There was even an oil facility at one stage. Don't know if that'll make a comeback. And there was a separate EU-sponsored scheme that I mentioned, Staybex, which somehow believed, this was the time of Claude Chesson, somehow believed that this could form agricultural insurance policies where the donor pays the premium and somehow prices, production prices, but also export prices could be stabilized, and farmer incomes in very poor developing countries could be protected. It was not a fiction, but it didn't work. And because of the lags in the supply of aid, EDF aid not excluded, it tended to destabilize rather than stabilize. So this was particularly bad for government revenues for countries dependent on a narrow range of exports. So moving on to stay pretty much within my in my time, I cannot honestly see Peru's scheme operating this way either domestically or in the international field. Staybex was really just a clé de répartition. It was just an allocation instrument, an allocation mechanism for EDF aid, and it didn't have really more economic content than that. And when it was perverted into covering minerals as well as agricultural products, of course, the mineral people took it, the miners took it to their heart. I was going to say, tell you about Aimé Césaire, but that goes right back to the 1960s, and we probably shouldn't go there, to the Congo and so on. So asked to look into developing countries' interests, I'm coming near to the end there, in a world where for nearly the past decade, most of the economic growth has come from China and its immediate Asian neighbors, who are fast exporters and so on. It's interesting to then switch to Latin America, where I'm not a Latin America specialist. Now, I looked at the two contending parties, and I assumed Guatemala was a lot poorer than Peru, so I thought, right, better back Guatemala, you know, the small guy, you know, and so on. And I thought that, if only because of the old French adage, ce n'est pas le Peru, because Peru is supposed to be rich and big and so on. But I looked then more carefully and looked at the GDP figures, and sure, Peru's is a lot larger than Guatemala's, 203 billion against 63 billion. It's about 4 times larger. But then I looked at GDP per capita, and it's a lot closer. Guatemala is 3850 World Bank estimate in 2015 this year, whereas Peru's only slightly larger at $4152 per head. So back to this dispute, and it seems appropriate to me that Guatemala won, or that Peru's claim was largely extinguished. Relate this dispute to dairy products, sugar, rice, maize, the maize that produces high fructose corn syrup, so that's a sugar product as well. Try to relate it to the current global negotiations and pressing issues. You know, do we get... And try to relate this to what's happening in New York at the moment, the 70th anniversary of the UN, the General Assembly, Sustainable Development Goals. There's not a single mention of trade in the development goals, but that's because trade is an instrument towards goals rather perhaps than a goal in itself. It's a means rather than an end. No, so I want to conclude by learning that this procedure helped to shield Guatemala from bullying by perhaps bigger trade partners, as well as strengthening their sectors and institutions and it certainly wasn't done by enforcing the price range system. And so it was a victory for WTO norms and values, and ultimately for the multilateral trade negotiations themselves, as opposed to the free trade areas. But there's one message I want to leave you with, and this is how I end, Darlington, thanks very much. It's said that the Doha round is piétining, you know, it's stumbling, it's slowed down, it's not very rapid. But there is, despite what I've said myself, and now, thanks to what Roberto Azevedo has said this morning in the FT, there is hope for the Doha round still, for multilateral trade negotiations. But there is a danger that mega-regional deals of the sort that Tony was alluding to, he was looking at it from an ASEAN perspective. There's the Regional Comprehensive Economic Partnership, which includes 2 of the biggies as well, China and India, whereas the TTP and the TTIP don't. But the point about these 3 mega-regional deals is that they're all exclusionary. They're all the opposite of what happens in this building against the WTO. They're not multilateral trade negotiations, and because they're exclusionary, they also exclude the subject I've been asked to talk about most of all, developing countries as a whole, small developing countries, small island developing countries, landlocked, whatever, you know, the little guys. And so I think we ought to be careful of that. Now, there is a risk that they may be trumped, that GATT and WTO agreements might be trumped by regional deals, by mega-regional arrangements and so on. But I think in the end, this House ought to have the strength to resist that. And remember, even some of the new trade policy developments, like MFN, came from bilateral arrangements originally in the 19th century in the case of most favoured nation status. Even duty-free, quota-free access has moved from bilateral to multilateral. So can mega-regional deals trump the WTO? No, I don't think it can, and I certainly hope it doesn't. Thank you very much.
Thank you, Adrian, for your comments. I'll now quickly invite the panel to comment on each other's comments, so to speak. And I'll start with Carolina. I'll give you 3 minutes to have a comment, each one of you. So, Carolina.
Thank you very much. Okay, 3 minutes. So, well, I'd like to say a couple of things. Let's start with the comments that we had regarding regional trade agreements. I just would like to, I didn't talk about that in the presentation because, of course, I had to put 100 pages into some slides. But it's also good to remember that even within the FTA has some provisions regarding the choosing of the forum, right? So even the FTA states has some provision regarding the possibility to go to the WTO forum or to use the FTA dispute resolution mechanism. So I just wanted to, and actually the appellate body also saw that, and it's part of the arguments regarding, well, the admissibility of the claim itself, because, so that's one thing. The second thing is, well, regarding Malgosia's comments, I think I have to agree, even though she said she's not a trade lawyer, but it seems after this case she is, because I agree that, in fact, the appellate body regarding good faith ruled very similar to what she said that a international public law tribunal would rule, in the sense that, well, it's a provision that it's not sufficiently analyzed in international law tribunals, so that I agree with that. From my perspective, in trade law, I'm very happy with this case, because I think this is the first time that the appellate body has referred so specifically to an FTA, and it has said so specifically that an FTA provision that is WTO inconsistent cannot go on. And I hadn't seen that clarity in other rulings before. So I think for me that's what this case is about, and it's really the I would say it's the most interesting part of the case. So regarding the FTA versus the WTO provisions, and in this case, well, the WTO provisions should prevail, and the inconsistencies should be clarified. So I think that's one of the most interesting parts, and that's why I said at the beginning of my presentation that I think that there is going to be a WTO before this case and after this case, because if this case is sort of a milestone, then maybe are we going to expect more cases like this? And this is also a question to you all. I see here, well, we have many of the colleagues from the missions, and so it'll be, yes, an interesting thing to take into account. What is going to happen with other cases with FTAs? Or you mentioned, Adrian, about the threat of some of the mega regionals. Well, we have the panel and we have the appellate body. Are they going to rule on any of these, if they come into force, if they are ever coming into force? Would they be ruling on some of the matters, given or if they are WTO inconsistent or WTO minus, right? This is a big question that arises. And to me, well, of course, I strongly believe that it is the mission of the WTO. So this decision kind of reinforces the role of the WTO and its dispute resolution mechanism before those. Yes.
Thank you, Carolina. Margosha?
Yes. Thank you. I have a very short comment which actually builds on Carolina's comments about relationship between FTA agreements and conflicts with other WTO agreements. It's already in relation to Article 31 3C, the appellate body mentioned the same subject matter. So what is it, if it is, you know, conflicts between different subjects between the both agreements? I mean, we have the conflict rule in Vienna Convention, which relates to the same, to the subject matter conflicting agreements, but it's a very narrow rule. So I, as a general international lawyer, perhaps naively would like to know what are the rules and regulations in WTO law in relation to conflicting norms between general and particular agreements.
Thank you. Tony?
Well, I'm glad Adrian brought up the issue of the mega regionals, and maybe I was being too polite. That actually many of the FTAs actually tend to be exclusionary. I mean, that's it tends to towards sort of a club. I mean, we've already there've been number of writers on this with articles about the impact of mega regionals and regionals and how these RTAs tend to overlap, and then the question of the disciplines that are embodied in this. Well, if you're talking about a trade agreement, it's very hard not to have disciplines that are also disciplines of the WTO. WTO has set out really in the Uruguay Round Agreement to set some kind of a framework for the conduct of all international trade. So invariably, anything that would be found in the provisions of an RTA would have some bearing on or have some involvement with the provisions or disciplines of the WTO. And the danger that you're actually carving out a new set of rights and obligations, and the possibility that you could actually, well, you can choose a forum, and then that forum could rule on issues that deal with what they call just exclusively the RTA provisions. But somehow the RTA provisions will always have some involvement with, these are trade measures, these are trade provisions. So there's still that challenge of the WTO now. It's just a political economy challenge to really assert itself and make sure that the whole world abides by this global framework of discipline, and maybe try to fold in and try to bring in the all these RTAs into a common set of or common understanding.
Thank you. Adrian?
Thanks. Three very short. Sorry. Secondly, for Carolina, on the panel rulings on conflicting norms, there is precedence there between FTAs and WTO agreements. For instance, Canada, US have come to the WTO dispute settlement procedure to settle their problems, even though there was a regional mechanism to do that within NAFTA. And so it's interesting that, and there are other cases as well that I'm not versed in, but people tell me they exist. And then lastly, to end up on a slightly more ironic note, Malgosia introduced me to the concept of historic good faith of France on its nuclear promises. I just wondered if that's more or less valuable than Volkswagen nitrogen dioxide readings. Thank you.
Thank you, Adrian. At this stage, I would invite the audience participants in this event to raise their questions or comments. Please be brief and be precise to the point. Gabriel?
I have a cold, I'm sorry, with my voice. I think there are various things to say, and I'll make only one comment. Just to support what Adrian said, we calculated that about 25% of the WTO dispute could be handled in regional trade agreements. So this is why when people say, oh, do you think regional trade agreement threatens the WTO? We usually say, well, certainly not dispute, because there's so many of them. When I arrived 20 years ago, we were about handful doing disputes. Now we're 60 staff. But I think the most beautiful comment in this Appellate Body report, and it was alluded, is a bit of a bitter dictum, because it was not necessary. It's in paragraph 5116, where the Appellate Body says clearly that the Article 24 of the old GATT, the principle that is there, is such that it's not consistent, it would not be consistent in an FTA to roll back members' rights of the covered agreement. And personally, the big fear of regional trade agreements is that we have noted 7 of them where in a bilateral agreement, the parties, usually the strong one, force the weak one and to not use the WTO dispute settlement system. So for instance, in the Switzerland EU, the chapter, I think, on SPS prohibits the use of WTO. So there's a fear, and I'm talking my personal capacity, that regional trade agreements are used to reduce some of the rights and impose obligations or modify fundamental things. And here the Appellate Body says it's against the logic of 24 that says you use regional trade agreements to improve market access, but not to reduce the DS rights and the automaticity. So yes, you can have fork in the road and all these forum clauses, but you better draft them clearly. And here they even open the door whether you could say this dispute can never go to WTO. And it's very important in terms of hierarchy, I think. The regional trade agreement is not the occasion to violate the WTO, and not the occasion to reduce, and I'm thinking of the Peru-US FTA on access to medicine, for instance. All sorts of things can be asked now.
Thank you, Gabriel, for those valuable comments. The lady behind.
Good afternoon, and thank you for your presentation. Indeed, I would like to follow up on Gabriel Marceau's comment. Actually, there is a WTO Secretariat paper showing that approximately 90% of all the WTO dispute settlement cases deal with regional trade agreement cases. And yeah, but this is for in general, and 25 counting also developing countries. So the percentage for developing countries is actually bigger that use the WTO dispute settlement, even if they have regional trade agreements that could actually deal with these cases. So my question would be for Anthony, and it would regard the discipline in trade negotiation because I think that it's very important, the drafting of choice of forum clauses. And there is often a discrepancy between these, I would say, generic clause where RTA parties say that they maintain their rights and obligations under the WTO agreements, but then they have other choice of forum clauses. Or they then carve out the WTO dispute settlement mechanism for some issues and then still use them for others. So what would be, in your opinion, also as first a trade officer negotiating trade agreements, what would be the way forward in order to draft these, for instance, for the clauses more clearly? And we have also to recall that in Mexico soft drinks or in Argentina poultry, it is still not clear where a fork in the road clauses would be considered as a legal impediment. So what would be your suggestion for that? I wrote my master thesis on choice of forum clauses for this issue, and I came to the conclusion that an idea would be to link this with good faith concerns and say that if you clearly relinquish to your right to access to WTO dispute settlement mechanism, you could then, as an opposed party, refer to that and say that bringing a case to the WTO dispute settlement, if you have bring it already to the RTA, would be in lack of good faith. What is your suggestion? What is your opinion about this? Thank you very much.
Yeah. So I think first we should apply your master thesis in all provisions of the or in all RTAs. But aside from yes, good faith clause is good, but I think the problem is we tend to put a motherhood statement regarding our adherence to WTO and of course that there'll always be the right to resort to the WTO dispute settlement. Then we come up with a whole dispute settlement process that could be alien, could be maybe patterned after, but could be also very alien to, very different from the dispute settlement process we have at the WTO. My suggestion is really to have a very specific procedure that involves that has I suppose it would have to have a very specific recourse to the WTO when it has to do with issues that deal with WTO matters, built into the clause or the procedure for the dispute settlement within. Because in the end, it's about interpreting the provisions of the agreement. But oftentimes they'll say, we're choosing this venue and everything is being decided within it. But you still have to have issues regarding WTO disciplines decided by the dispute settlement system. So I think all RTA should probably have some clause or some provision that allows for a specific procedure towards the dispute settlement system.
Carolina, would you want to supplement that?
Yes, thank you. Just a quick comment on that. I agree with Anthony regarding FTAs and RTAs, but also remember that I mentioned here when they analyzed good faith, the appellate body, and it's been said in AC Bananas 3, paragraph 211 also. If a member thinks that this going to the DSU, going to the appeal mechanism of the WTO is effective for the provisions to be WTO consistent, then they can get to the system. So also seen from another perspective, not just from the RTAs and FTAs, that yes, it should be inserted, the provision, but if it is not, let's say it is not, I would say that a panel cannot reject a claim based on that argument, on good faith, because of easy bananas, because it's also here in this one. So I would say it wouldn't go ahead in that way. I mean, it would be seen by the panel and the appellate body, well, in this case.
So it cannot reject the case?
It cannot reject the case, yes.
Based on good faith?
No, meaning that it wouldn't be bad faith of the complainant, exactly. Yes. Mm-hmm.
Thank you. Magosha, you want to say something?
Just one, I think one general comment that what I really liked in this judgment, in this decision, of the appellate body was that they said that bad faith shouldn't be, that good faith should be presumed. So bad faith shouldn't be presumed. Mm-hmm. And I think that this is actually the main also basis of international law, that we always presume good faith on the part of a party.
Any?
Just one more.
Yeah, sure.
That was a big, it was explained also, a lot of discussion on this in this whaling in Antarctic case when a good faith of Japan was put into question. Thank you.
Thank you, Magosha. Yes, the gentleman there.
This is to bounce back on Anthony's comment. You mentioned that you think there should be a disposition saying that you should go to the dispute settlement system in case there is an issue in a regional trade agreement. But why is it a necessity? I mean, the European Union has a disposition that says exactly the opposite, that says if a dispute is the least bit covered by the EU's field of competence, then you should deal with it within the family and not go outside of it. So why would there be a need for a recourse to the WTO here?
No, I think the issue or the problem is, I mean, as correctly pointed out, it does help if RTAs can actually relieve the burden of the dispute settlement system, because the dockets are so full, and then they're going to be heavier. But what we've observed here in the case is an issue of a provision which is not WTO consistent, that is being argued as having been waived. The right to question it has been waived because it's already embodied in the FTA. So the FTA itself, or the RTA itself, has to be WTO consistent. It's not so much that we want to downgrade or downplay the existence of the mechanisms in the RTAs to be able to facilitate sort of a faster resolution of cases within that, especially if it's within the competence and according to the provisions. But when we're talking about, I guess, the possibility of waiving or carving out from the basic disciplines of the WTO, then there's a problem. That's what has to be addressed, making sure that everything is consistent with the WTO. Then there'd be maybe no need to actually lessen the participation, or maybe even increase the participation of DS mechanisms within RTAs.
Thank you so much. My question is to Ms. Carolina. As pointed out that the orbiter part, paragraph 5, it may not be the ratio, but it goes a long way to ensuring that future FTAs are not WTO incompliant. That is, WTO minus provisions can no longer be included. My question is that in this case, the complaining party happened to be one of the FTA members. What happens in a dispute where the complaining party is not an FTA member? Can third parties bring up such disputes? And if they can, how do future TPPs or further RTAs where the complaining party is not a member, how does it come up then? How does it play out then? Thank you.
Carolina?
Thank you. I don't know if I understood correctly, but if I understand what you're saying is what would happen if, in this case, the claimant were not to be Peru, but some other country, for example, Brazil, that is not a party to the FTA between Peru and Guatemala. Well, then WTO would have taken the case without even looking at the FTA, because if Brazil's products, in this case, well, sugar, maize, etc., would have had an impact because of this price range system, then they can, of course, challenge the measure before the WTO without a doubt, right? Actually, there were also many parties participating as third parties in this dispute, and they posed some interesting questions and they gave some interesting statements as to how the panel and the appellate body should rule. So they were also interested. But yes, so that would be, if I understood correctly, yeah. Mm-hmm.
Thank you, Carolina. The gentleman at the back, you wanted to pose a question?
No, I found this question very inspiring, and possibly I could a bit replicate it in a modified version. Let us assume we now in services we do have among the 120 regional trade agreements, possibly 60%, 70% contain provisions that are WTO inconsistent. That's undisputable. Now let us assume that a third country challenges such an RTA, claiming or insisting on the MFN extension of a positive, of a GATS plus element, arguing that the whole agreement does not live up to the standards of Article 5. Then we would have a third-party effect. And how would that then look like in your view?
Thank you. I don't know. I don't know how to answer this because this was not in the case. This would be a completely different case. And if I understand you, maybe that was what you wanted to ask as well. But if a third party would challenge an RTA, given that that third party is not part of that RTA, because there's a provision that is WTO inconsistent, I believe, but we would have to look at of course, the facts. That if there is an interest, a legitimate interest of that third country in that provision for a reason, then I think there would be enough base for admissibility. I don't know how it would rule in that case, but I think if there is a genuine interest because of a trade distortion that is ongoing with that third party, then I think maybe there's enough argument for admissibility, at least. I don't know how it would rule, but at least regarding admissibility, I would say so. Of course, it's hard to tell. We don't have a case like that. This case is different. But those are some of the questions that are really interesting from an international law point of view, from a trade law, from a forum choice point of view, because I think this case is going to give us a lot to talk about. It's not just about the 1 or 2 paragraphs that we have here or about the outcome, but there's a lot of implicit implications that I think we need to take a closer look at and imagine what would be the possible scenarios about this. Like, for example, let's say that the FTA, in this case, was ratified by both parties, for example, given that that is also an argument. Let's say it was ratified and it was enforced by both of the countries. Would it had a different outcome or not, right? So yes, it's more an ongoing question than an answer, I'm sorry.
Thank you. Would we want to move on to another issue? If there's any question, or we still address, I can see you wanted to make a contribution. Please go ahead.
If I may comment, I agree that it is a very interesting question. However, I think that it is more an academic question, because what has happened so far, and even regarding the transparency mechanism of RTAs, what you see is that if that would happen, then every member would start to bring to the dispute settlement each other member. Because as you noted, there are plenty of WTO inconsistent provisions in RTAs. So this would be a domino effect, and that's why no one or no country bring these measures or these provisions to the WTO dispute settlement mechanism, because they fear that then another country would do the same. So I think that politically it would not happen, or it will, happen in very, not in all circumstances. And what I would like to say in regard to the clause that I was referring is that, the problem of fork in the road clauses in general is that even if you create a fork in the road clauses, if you translate the obligations that you have under an RTA, under a WTO obligation, the fork in the road clause can lose its meaning in essence, because still it is a WTO violation and a panel has jurisdiction over it. And we know that it is impossible for a panel to deny jurisdiction if it is validly established. So what I proposed is that the clause is carefully drafted in the sense that it does not refer only to RTA's violations, but to violations regarding the same or similar or substantial subject matter, giving some space for interpretation for the panel in question. Thank you.
Thank you. Are there any other questions or comments? Margosha, you wanted to make a comment.
Just a question, maybe, which again comes from my ignorance a bit. The compatibility issue with FTA and general agreements, it's a very general statement, compatibility. Is it in some ways maybe precise and some kind of definition what is compatibility, and of course what is incompatibility? So where's compatibility is okay when incompatibility starts, and what are the measures taken in cases of incompatibility?
Do you mean incompatibility between the RTA negotiated and the WTO
Yeah.
provisions? Well, of course, as I said, just about all RTAs tend to put a pronouncement of their intention to adhere to WTO standards. But, well, you'd have to, I guess, go into the fine print. Provisions of regional trade agreements tend to have very similar language. And in fact, my observation sometimes whole provisions are written not by lawyers, but actually technical people in the section or department involved. Then it tends to not be it doesn't have that the same sort of screening that a legal scrubbing or a legal expert would have. And that might lead to maybe portions of RTAs not looking consistent or not looking compatible. And that's when maybe you find that, yes.
Any other contributions? I'm trying to, yes, please go ahead.
Just a quick question. I would like to take advantage of Professor Fitzmaurice's ignorance, which he has admitted, and ask two questions. In a situation like this one, in this dispute, where the FTA had not entered into force, so the dispute settlement clause had not entered into force, let us assume that there is a valid FTA, and it has a dispute settlement clause where the parties are required to choose the forum, either the RTA or the WTO. And despite a measure having been reviewed by a tribunal in the FTA, the party that has lost the case goes to the WTO and initiates a case like this one, although it has already been resolved in the FTA. Under general rules of international law, would that be contrary to good faith or not?
So the FTA is in force, yes. The dispute was brought to panel.
And now there's another one in the panel. There were situations.
Yeah, and it is an appeal from the panel? No, it's a new case.
The other parties are arguing that
On their different forum.
contrary to good faith, what should the under public international, general international law, the assessment, the evaluation of this action?
I think that it would be very difficult to call it a bad faith anyway. Would it impinge on the first judgment in some ways?
So it's a problem also under general international.
Yes, but I don't think it's going to be, yeah, but we have to look at the results, how it would impinge on the first judgment, whether the action of the states would could be called abuse of rights even. Yeah, it's a question of good faith as well, and whether it would impinge on rights and obligations of third parties involved. And then I suppose it could be bad faith, but it will be very difficult to prove, I think. Yeah.
Thank you. We have one online question which is from Tracy, and it says the current trend of regional free trade agreement negotiation is also to have deeper integration. more WTO plus obligations. What is your view on the forum selection for those type of obligations? Can WTO handle disputes relating to those type of obligations? In the preliminary rulings of Guatemala U.S. labor dispute under Article 16.2.1a of CAFTA, the parties and the FTA panel indeed also refer to the WTO jurisprudence to support their arguments and reasoning. Could you please comment on the value of WTO jurisprudence in FTA dispute settlement? Anyone?
Ladies first.
Yes. Well, usually FTAs are negotiated on a base of WTO obligations and WTO law. So I would see this, I actually see this as a normal, well, Anthony might comment on this as well, but I see this as a normal negotiating practice that WTO provisions are actually incorporated into FTAs, and even if there are regional cases that WTO jurisprudence or WTO law in general could be brought to regional dispute settlement bodies as well. I would see it as a as a normal practice. Maybe you can comment further on that.
You know, technically speaking, you don't have a jurisprudential system in the WTO system like you would find, let's say, in a common law country, or countries that tend to refer, or where in the decisions of the judicial system tend to become part of the law. But having said that, actually the decisions in disputes, even beyond or outside of the WTO system, or before you get to the WTO dispute settlement system, does make reference to many reports and appellate bodies, even at the national level. In other words, you have a trade remedy case. Actually, I've seen lawyers actually cite decisions of past appellate body reports and panel reports referring to, let's say, due process provisions in anti-dumping cases. So I suppose it would have a very persuasive effect, especially for an RTA that has a declaration of WTO consistency, or the WTO plus provision.
Thank you. Any other contribution? Yes, please.
Very, very quickly, because the time is short now. It is interesting, very interesting, that a small country can challenge a measure such as this case. But the issue, the real proof will be the implementation of the findings. Just a brief comment on PRC. The price range system is inspired in the banda andina de precios, which goes a lot of time long ago, and also in the variable levy of the EU. And it's a device to stabilize prices that for inputs that coming into a certain market. But the price floor works, really. There's no way to import under the minimum price. So it's clear that it's incompatible with Article 4 of the Agriculture Agreement. Regarding compatibility between FTAs and WTO obligations, there can be real problems, really. Uruguay has been subject to an anti-dumping procedure last year concerning rice. And rice coming from a different origin with preference was excluded from the calculations of the dumping. So that costed us a real trouble on how to deal with that. That's a specific consequence of this situation. Thank you.
Thank you. Are there any contributions or questions to the panel? I do not have questions online neither, So I will invite the speakers to make some final comments, if you may, starting with Carolina, very briefly. If any.
Yes, well, thank you, moderator. Well, there's much more to say about this case than we have said here. I think, like I said before, it's interesting to look at the fine print and to really read carefully each one of the arguments that the appellate body cites, because then the question that we all have is, because of this tiny door that has been opened of an appellate body looking into the provisions of an FTA, we may have many other questions. What could happen in this case, in another case? Of course, each case is different, and of course, there's no obligation to cite past cases, but we also wonder if this is going to be a new kind of ruling or a trend that we're going to see happening more often in the appellate body or the panels at the WTO. So that's very interesting. And I also think this case may be a little bit underrated as well, so we can look further into, again, some of the arguments and analyze how they could be developed in the future, in future disputes or in future agreements or in mega-regionals or in regional trade agreements, and analyze which are the particularities and how this opens a little door for us to bring these disputes into dispute settlement of the WTO.
Agosha?
Yeah. Thank you, Mr. Moderator. I would like to say that I learned a lot today, and I think this case is very important from the point of view of general international law, and maybe indeed a bit underrated, but I think it's a very fertile ground for dispute by international lawyers in relation to treaty interpretation and very pertinent issues of coexistence of different rules of law. I also think that it should be actually, from this point of view, should be more collaboration in general between WT lawyers and general international lawyers, because we miss out a lot on a very important case law and jurisprudence of WTO, and basically it shouldn't be like that, because this case has proved that it added a new dimension to several to article on treaty interpretation, and especially 31, 3A and 3C. So I think that this is very important. Yeah.
Tony?
Well, I'm very happy and thankful. I was actually made to read through 100 or so pages of this case, and I do agree it's underrated. It's something that I think it's a very good choice as a case study. And I personally don't, it's not that I have anything against RTAs. No. My own reflections that come from this case is really more of the quality and the standards that we have in our RTAs. RTAs can be a very useful way of actually integrating further, and it could actually strengthen the multilateral system, but it has to work in conjunction. And when you go through RTAs, the problem is, and as a lawyer, you know that the devil is in the details. No? Sometimes you gloss over a notified RTA, and it looks fine. It looks like it has no inconsistencies or incompatibilities. But when you do read and understand its impact on its usage, its actual implementation, you could run into problems. So I think there has to be some effort politically to really have a concerted effort of the WTO working together with all the RTA negotiators to make sure that the whole system of RTAs is also part of the multilateral system. And the more effort we put into this, I think the less problems you'll have, and maybe the less controversial cases we'll be encountering in the future.
Adrian?
Well, as a valedictory comment, only to wish you all well, especially those of you in this establishment who are working on, whose job is to tweak or reformulate properly multilateral trade negotiations, because you really do have my good wishes. As for mega FTAs, I can do an ad, because this coming month, in the middle of October, there's going to be an ODI meeting precisely on this. So maybe something I've said today gives you a preview of that, although I'm not one of the speakers. The speakers are going to be Jim Rollo of Sussex, Sheila Page of ODI itself, and Ganeshan Wignaraja, who's now of the Asian Development Bank, or I think Asian Development Institute, isn't he now? He's going to be in London for that. If you go to the ODI website, odi.org or odi.org.uk, you can find the details. But it's in about 2 or 3 weeks' time. My last comment, well, remember that mega RTAs, mega FTAs may never happen. They may never be ratified by Congress, the Diet, and so on. So we may be all wasting our time. Thank you.
Thank you very much, panelists, for your comments and contribution to the understanding of this particular dispute. This concludes our event. But may I take occasion again to thank the co-organizers, WTI and ICTSD, for your and also the participants for your active participation. A big thank you again to our speakers, the Permanent Mission of Finland, the WTO Conference Service, the ICTSD support team, and everyone that assisted in organizing this event. We kindly remind you once again to fill out your feedback forms and leave them behind. Before I close, I just want to mention that at ICTSD we are in the process of organizing our Trade and Development Symposium, which will be held back-to-back with MC10 in Nairobi. This particular event is being launched on the 1st of October between 12 and 13 here at the WTO, being led by our CEO, Ricardo Mendelez. I think that you need to take time to come and understand which themes will be covered and so forth. It will be an interesting spectrum of discussions. So please look out for this forum. So we end the meeting by looking forward to seeing you again at our next Talking Dispute event. Thank you very much.
Congratulations, Mr. Chairman.
Yeah, congratulations to you. You flew all the way?
Yes. So I had to ask, please give me an extra day.